Mr. Ajay Tyagi, Additional Secretary, Department of Economic Affairs, Mr. Onkar Rai, a great industrialist of India and otherwise keenly associated with the growth of India in various capacities. Today, these days with BRICS, Mr. Khaitan, distinguished lawyers, delegates from abroad, young friends, ladies and gentlemen. Today it is indeed an extraordinary day where we are discussing the challenges, opportunities on the road ahead in the international arbitration in BRICS. It's a very timely conference, and I'm indeed honored that I have been given the privilege to inaugurate it. What does BRICS represent in substance? It is 30% of the land area of the world and 42% of the world population. BRICS therefore occupies a seminal importance in the geography of the world. But it is not confined to geography simpliciter. It is equally having a dominant say in the economy of the world. The figure which I have been given is their combined GDP is close to 16 trillion US dollars, which in essence is approximately 20% of the world GDP. And over the years, they have come to play a very important role in the world trade, economic intercourse, and investment, both inward and outward, FDI in particular. I am given to understand that starting with 10 billion in US dollar in 2002, the share of FDI inflow in the world has increased to 21% in 2014. And the outflow increased from $31 billion in 2005 to $185 billion in 2014. Tyagi, you need to do the latest statistics also. The last one have been given to me. But what does it indicate? It indicates the growing importance of BRICS countries, closer cooperation, closer interdependence, and above all, the need to play an important role in the world affairs. That's how I see the role of BRICS. Whether it's China, whether it's India, whether it's South Africa, Brazil, all, Russia, are important countries of the world in their own way. And they have sought to leave their own imprint on world affairs. But their coming together is a seminal statement being made. That here is a group which is willing to be engaged with the world. Here is a group which is intending to understand, adopt, and participate in the international standards of world business. But here is a group which is also a voice, whose voice needs to be heard. That's how I see, ladies and gentlemen, the larger complexities, ecosystem which the BRICS have developed over the years. It is a global world. Interdependence, engagement has become the order of the day. Reform became the buzzword. And what is important is that all these countries in their own way open their gates for investment, changing the business ecosystem of their respective countries, welcoming FDI, and also giving a good space for investors to work and earn good return on their investments. Surely, investors did not go to these countries for the heck of it. If I'm allowed a degree of frankness, they went there because it also gave good returns. And these countries in turn welcomed and respected these investments and also created the ecosystem where you do invest, let business prosper, let economic activity get accelerated, and you also get good returns. This has been the by and large general trend of BRICS countries. And as a student of India's politics, having some interest in world affairs, and being an activist from my student life, one of the most remarkable consequence of this understanding of the New World Order has been that regardless of their internal ideological government apparatus, there has been a general consensus on the need to participate in the world economic order. That has been the most important initiative taken by these countries. We in India, today reform is not a debatable issue. Today reform is not a luxury. Today reform is important. As our Prime Minister says, we have to reform, we have to perform in order to transform. And this transformation cannot be purely incremental. It must be on fast track. And what he said yesterday in a very important Niti Aayog function, we cannot handle the affairs of 21st century by the ideas and administrative apparatus of the 19th century. That's the importance he gives on reforms. What we did, we relaxed the FDI norms in nearly all the segments except few. We made a friendly ecosystem. We laid down new standards of ease of doing business. And today, India is home to nearly 50 billion plus of FDI, the highest ever in the history of India. I was just examining in ease of doing business. We were ranked 147 in the World Bank record of ease of doing business. And thus 1 year, we jumped 12 rank to come number 13, to come at 130, I'm sorry. Therefore, we are changing the entire ecosystem. We have undertaken some very path-breaking reforms initiative designed to make India an empowered society, knowledge economy, make in India, digital India, startup India, skill India, stand-up India are important milestones designed to change the entire architecture of India and make India a knowledge-based economy and a knowledge-based society. Ladies and gentlemen, what is the digital profile of India? In a population of 1.25 billion plus, we have 1.3 billion mobile phones. In a population of 1.25 billion plus, we have 1.4 billion Aadhaar, digital verifiable identity kept under very strict confidential conditions. Where at the click of a button, you can get the face, the iris, the fingerprint, the mobile number and address of every Indian. We have got nearly 400 millions today on internet, 60% through mobile. And what we are doing is, we are tapping technology for good governance. For instance, we give subsidies to poor. We open their bank accounts, those who did not have bank account. Within a short time of 8 to 9 months, we open close to 230 million bank accounts, 23 crores of the poor and underprivileged. And what we have done? We have tapped their bank account to their Aadhaar, the digital identity, and to their mobile phone linked to their bank accounts. And what we do? We straight away deliver subsidies of various segments to their bank account. In the process, we have saved close to 6.5 billion US dollars, which used to go waste or being siphoned by middlemen. Therefore, by the application of technology, we are focusing on good governance and quick delivery. Surely, many other countries are also doing that. But what is important is some of these steps which we have taken. We have got appreciations from a lot of international bodies. First among the world's fastest growing economy, source International Monetary Fund. First among 100 countries on growth, innovation and leadership index, source Frost and Sullivan. Next, first among the world's most attractive investment destinations, source Ernst & Young, 2015 reports. First among the world's fastest growing economies in both 2016 and 2017, source WASP report 2016, United Nations. And last, first choice for tech MNC to set up R&D centers outside their home countries. Again, these are there. Therefore, this quest for good governance, openness for seeking investment, and creating a new order of equity and growth for the poor and underprivileged is a great challenge of many of the countries which comprise the BRICS segment. And I'm sure other countries too are doing the same. Now, with increased economic activity, with more and more of FDI, surely there will be disputes. And there is a need for a good mechanism for resolution of those disputes. Here I would like to add a caveat. Yes, the world is becoming global. And the global world is one of interdependence. The global world is one of involvement. But the world will never become truly global if it is delinked from the local. The local must have a say in the global. That is very important. And that will be a global world, would be truly a representative world. This is how we see. I'm sure this whole dispute redressal mechanism will also have to reflect upon these concerns. There have been gains, there have been improvement, there have been ideas, there have been good cases, there have been instances where cases have been resolved. But there are also areas of gaps, and there are also areas of concerns. I think you are going to deliberate upon these in a very, very profound manner. What are some of the concerns? Let me, ladies and gentlemen, very briefly share with you that. When you go for investment, you need to have a bilateral investment treaty. There is a format for that. There is an ecosystem for that. But what is the experience, empirical evidence? Not only BRICS countries, but many other countries from Latin America to Indonesia started thinking very quickly that we need to revisit these bilateral investment treaties. They are not working very, very satisfactorily. And if a huge chunk of world countries and world population and those engaged in business have these lingering, deepening concerns, then there is something wrong which needs to be addressed. South Africa was the first to acknowledge it, and they have terminated their investment agreement with a number of countries. And they introduced a draft promotion and protection of investment bill to provide for a different framework. I'm given to understand that even Brazil is focusing upon joint committee of ombudsman comprising government representatives of both parties to resolve disputes of investors in amicable manner. Therefore, there are concerns. And this interaction today, which is of great importance, would really become a milestone if these concerns are properly debated, answers found, and the roadmap for future laid. In India, we came with the 1996 Indian Arbitration Act, which also subserved the need for international arbitration obligations and compliances. There were concerns, and being an open society governed by a constitutional democratic polity, we said we will hear the stakeholders. We heard them long, and ultimately we came with amendments in 2015, and now the amended Arbitration Act has also come into force with rules clearly laid down the whole manner of dispute redressal. What has been the Indian experience as far as these bilateral investment treaties are concerned? I would say it is a mixed experience, and at times not very happy one either. We signed 83 investment agreements, ratified 73, based upon the Model Investment Treaty of 1993. But ultimately, the experience showed that interpretations are being done in a manner which are quite ambiguous and also giving rise to concerns. Now, a new Indian model BIT has been provided for to ensure the protection of foreign investment and also taking care of the country's concern. Well, ladies and gentlemen, I talked to the Legislative Secretary that do I have the liberty to be a little frank, though I'm the Law Minister of India. He said, go ahead, and I take the consent of the podium, Khaitan, you too, and Omkar, you too, that I need to be a little frank. What is the international ecosystem today, ladies and gentlemen? The international arbitration system is ad hoc and quite frequently unpredictable. That concern is indeed very, very important. Yes, I take the point of Ajay Tyagi, that is Secretary. If BRICS countries occupy 42% of the world population and 30% of the geography, and they are contributing so much in this whole investment and economic ecosystem of the world, global world, why we see less and less of arbitrators from these countries on the world dispute redressal mechanism? This has always troubled me and also baffled me. The second question I would like to raise here, ladies and gentlemen, today, why should there be a presumption that a fast alternative arbitration resolution delivery can come only from arbitrators who are trained in the Western legal system, who are from the Western world or the first world? These are important issues. They need to be articulated. I am very proud of my judiciary. I have been a part of it, as many of you sitting here are. India has produced some of the finest judges. But why we see only a very small fragment of them getting represented? I'm sure the same is the case of South Africa. The same is the case of Russia. I was told that 69.8% of the arbitrators on these international arbitration processes belong to the first world or the developed world. I only hope it is not wrong. But if it is a rather sorry state of affairs. The second is the complete lack of any appellate mechanism. An order has been passed, penalty has been imposed, heavy penalty has been imposed, the matter stands closed. Do we need to consider some kind of very limited appellate mechanism at the international architecture level? This forum shopping, you are having a contractual obligation, you go for municipal courts, you go for international treaty obligations also. Is it right or fair? Having the best of all the worlds? Whenever I see, as a law minister, I have to see all these awards being given to us. They have to pass through me. The first thing I look at, how much of penalty has been imposed. And whenever I see the quantum of penalty, my eyes get wide open. Because with my long experience in the legal profession, I have rarely seen this kinds of penalty given either in arbitration or by the courts. Should, and this is the larger question I am flagging for your kind consideration, should 1, 2, 3, 4, 5, 10 investments and the dispute arising therefrom should lead to a dispute redressal with penal consequences which are designed to unsettle the economy of the country where the investment has gone. That's a larger issue which this interaction must need to consider. There are two more issues I would like to flag in this connection, ladies and gentlemen. One is the need for having investment. Yes, okay, why not? The second is the sovereign right of the investee country to regulate. How do we synchronize the competing claims of both? Second, when the arbitrators of these international investment dispute redressal go for consideration, in most of the cases, they are not sufficiently briefed or acclimatized with the domestic laws, which also do have a bearing or not. And thirdly, when you go for dispute redressal, do you have any priority of the social concerns of the country where investment has been made, of the poor, of the underprivileged, for the equity? Or should it be treated as a simple business case between two business partners? Therefore, the sovereign right of regulation, the lack of getting acclimatized with the domestic laws of the country concerned, and the competing claim of investor and the need to balance the social consideration of the country where investment has been made. These are some of the very competing issues which will have to be considered. Let me make it very clear, ladies and gentlemen, that when we are a country governed by the rule of law, and we're very proud of our democracy, as we say, in appearance, our democracy may look a little noisy and chaotic to the foreign friends, but Indian democracy is very sound, and people of India know that they can unseat any political leader, any political party by the power of their franchise. And today, development and good governance has come to the core of India's political discourse. And that explains why we are here, and that explains why our Prime Minister won such a massive mandate. That's how we are working. But having said that, when we say that we welcome investment, we are keen for dispute redressal as well. We are keen that awards must be implemented. We are equally keen there must be stability in dispute redressal. These are important. Our Mumbai is coming as a big hub of international arbitration. I am very keen that Delhi also becomes that. We are in talk. And we are very keen to focus India as an important center of international arbitration and dispute redressal. Because this brings me to the last point in this connection. Why should some centers of the world become the center of international dispute redressal? Why? I don't want to name any country, but I hope all of you understand what I'm hinting at. Why should only some Queen Council barristers keep on roaming about from one arbitration to another? Why? I think these are concerns which must be appreciated. And these concerns I'm articulating as an Indian, as the Law Minister of India, but equally a person, as a senior member of a council of a government which is keen for international investment and FDI. But yes, these are occasions where these concerns must be articulated, designed not to criticize or to berate, but to find a proper solution for which we are here. Ladies and gentlemen, I warmly greet all of you. I am given to understand that you have basically taken three issues: evolution of ADR mechanism within the respective jurisdiction of the member states, statutory framework governing arbitration, recent trends on international arbitration involving BRICS member states, any other notable references. I think the notable references, Ajay will bring in a lot of references. We must be flexible and liberal too, so that there is a meaningful exchange. I only hope that a very positive outcome will come out of it. It was wonderful talking to you. If I have been a little frank, I have sought your indulgence, but that is what I came here to provoke, a good debate. Namaskar, thank you, Jai Hind.